The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Family law attorney with O'Flaherty Law, and today I'm going to do a how-to video on how to fill out Wisconsin Civil Court Form 405, which is a petition for temporary restraining order and or a petition and motion for injunction hearing. So let's start at the top of the form. You'll see State of Wisconsin, Circuit Court, and then a fillable space. You enter your county of residence. Here is the name of the person to be protected, and that's the petitioner. So if you're filling this out and asking for protection, that's you. You just put in your name here. Then you'll see the versus, respondent/defendant. You'll enter the name of the person that you're asking the court to enter a restraining order against. You can fill out the address for the person if you know it. It helps with service or locating the person so that they can make sure that the respondent is properly notified of the hearing that will take place on the temporary restraining order. A person other than the petitioner is allowed to fill out the form, and you would enter their name here. Finally, you need to put in the date of birth of the petitioner on this line. If it's your first request, you don't need to worry about the amended checkbox. But if this is a changed request from your first request, where you have additional facts or things that you need the court to know, then you would hit amended. Don't worry about the case number. The court will assign you one when you file the petition. This area is left blank. That's where the clerk of court will file stamp when the petition is filed. So you'll see a highlighted line down here. This is a CHIPS proceeding involving the child or the respondent is a minor, as in the respondent who you're asking for protection from is under 18. You'll use a different form. That form's listed here. You would not use the form we're talking about today. So next, they want to know some basic information about what the respondent looks like. The sex, race, date of birth if you know it, and your best guess on the height and weight. Obviously, it doesn't have to be approximate. Hair color and eye color. Next, they're going to ask you what the petitioner's relationship is to respondents. So how do you know this person that you're asking for protection from? And they give you a whole bunch of options like spouse, current live-in relationship, grandparent, even child. So if none of these fit, you've got this little catch-all here, and you'll see this throughout the form, and it just says other. And if it were, for example, a former coworker, I would hit other, say former coworker, and then identify which place of business the two of you worked together, just to give the court a little more information on where this person even came from. To the right of that is another box where they're asking for any more information you have that distinguishes the respondent. So scars, marks, tattoos. If you have some, great, but if you don't, it's not, the end of the world. You can just click none, no. This next section is very important. That's why they've got the caution box and they say check all that apply. The court and the local police want to know if this person, the respondent, has access to weapons. And they're not typically thinking kitchen knives or baseball bats. They want to know if this person has any guns or anything a bit more serious that they would need to know about prior to service, or if it could create an ongoing problem for you right away. They want to know if this person has any guns. And they want to know the location of the guns. So for example, if you know this person is a hunter and has a gun safe in their truck and they take a hunting rifle around town with them, you'd need to tell the police about that. Finally, in this section, they want to know if there were any weapons involved in an incident, past or present, involving you. So, were there any guns pulled out in an encounter that you had with respondent? Did you say you had any guns? Anything like that? You want to clarify to the court if that happened, and make sure that you get it on your petition right away so that you're not holding anything back. Next, we go down to who you are and what you want. So the petitioner, or the person who's filling the form out for petitioner, would select one of these options. You're the petitioner, you're their parent, step-parent, legal guardian, or even the guardian ad litem for a child. Once again, you'll see the other option, and you can always click that and then explain who you are and what your relationship is to the petitioner. The next step is where you say you petition the court for a temporary restraining order and injunction. The relevant law for restraining orders in Wisconsin is Wisconsin State Statute 813125. And they break it down into parts for you so that it's a little bit easier to understand what you need to say in order to get the court to grant you relief. So in paragraph 1, you see, stated below or attached as part of this petition is a statement of facts indicating that respondent or defendant has engaged in conduct which is believed to be harassment. And then the petition will give you a definition of what Wisconsin law thinks harassment is. So they'll define it, they'll say harassment is defined as, and then to briefly restate, physical abuse, child abuse, sexual assault, stalking, or attempts or threat to do same. So they don't actually have to stalk, but they might be threatening to stalk, like, I'll be following you to work today, or I'll be there waiting for you when you get home, something like that. And then finally, in subsection E, you see that there's kind of a catch-all here for behavior that would upset or intimidate the average person that's kind of nebulous and kind of turns on the facts of each situation. So subsection E is engaging in a course of conduct or repeatedly committing acts which harass or intimidate the person and which serve no legitimate purpose. So below this explanation in paragraph 1, you'll see that the form gives you 2 lines to explain what's going on and why you need protection from the respondent. I doubt this is enough space for most people, and I think they understand that too. That's why they give you the C attached. What I would do if I have more than 2 very short lines to say when I'm giving the court the statement of facts is I click C attached. And then to keep things organized, because it's probably going to be more than one attachment, I would say on this line something like C attachment 1, statement of facts. Just to keep everything organized so that when people are trying to refer to what you state in your petition, everybody can find it. Next, the court wants to know if there's another no contact order between you and the defendant or respondent in another state. Now, you can say there isn't one, or I'm not sure if there is one right now. For instance, maybe you had one 5 years ago and it's expired, it's run out. Or if there is a current one, you would click yes, and then give the court as much information as you can about where that order is. Name of the other case, county or state, if not Wisconsin. For instance, if you had something in McHenry County, Illinois. What kind of case number if you know it, date of proceeding, and the details. And even though there's no C attached box here, you could always just write C attachment number 2 and lay out the details of what led to a no contact order in the other state. After you've given all the background and the statement of facts that the court needs to understand what is really going on, you make your request. I request that the court, 1, issue a temporary restraining order requiring the respondent to, and then you've got multiple options you can ask the court here. And you can ask for more than one because it says mark any of the following boxes that apply. So you'll go down and you'll see these letter options under this number option. And you'll just click on the ones that you believe are necessary. So obviously, stop harassing me, stay away from my house or my place of work, don't contact me anywhere and in any manner, don't hurt my dog or my cat, allow me or a friend to come get my dog or my cat, don't contact me, and don't get anybody other than an attorney or a police officer to contact me. This is a catchy one because sometimes a lot of people who have a restraining order against them will get a friend or family member to reach out to the petitioner who asked for protection. You can't do that if this is clicked. Avoid contacting the petitioner or causing any person other than a party's attorney or law enforcement officer to contact the petitioner. That's it. Don't, if I get a restraining order against you, I don't want to be hearing from your second cousin who lives down the road, who you gave my cell phone number to. Then once again, we see the very helpful other category. So if there's something not on the list, but you think is relevant, specific behavior that you want the respondent to stop doing, here's where you would add it. And obviously there's not a lot of room here, so I would just click other, and then I would say, we're up to attachment number 3. I would say, see attachment 3. Then, because you're asking for a temporary restraining order, you need to ask for a hearing on the petition. And it gives you all of the same options as above. So I would just click whatever options I clicked in paragraph 1. I'd repeat in 2. And again, if you have to click other, and you already put attachment 3 up here, I would just say again, see attachment 3. So paragraph 3 is a little bit tricky. If the temporary restraining order is denied, the petitioner asks the court to schedule an injunction hearing. And then the form tries to explain to you why you're dealing with this option here. So if the temporary restraining order is denied, the petitioner is only entitled to an injunction hearing if the petition alleges conduct that is the same as or similar to conduct that is prohibited under State Statute 94032, which is the stalking statute, or as the intentional infliction of physical pain, physical injury, or illness, or as the intentional impairment of a physical condition, or as a violation of, here's a big one, Section 940225 subs 1, 2, or 3, sexual assault, or as a violation of 94301 involving destruction of property that belongs to the individual, or as a threat to engage in the above-mentioned behavior. So if your petition doesn't fit any of the harassment definitions, but somebody's threatening to burn down your house, that would fit here. And you could click that. Paragraph number 4 asks the court to issue an injunction against the respondent for 4 years or for the following shorter period. And you would lay it out here. 4 years is usually the max in Wisconsin. Here's a section that had to be put into the form when everybody started getting cell phones. If the parties have a child together and the account is in, we'll say, father's name, And that includes mom's cell phone and 12-year-old child's cell phone. This is in order to transfer it over so that they can continue to have cell phones. It's kind of an odd but specific requirement. So if you have an ex and they are refusing to give you the privacy of your own cell phone number and you don't want to change your number, this would be how to get them to do it. Paragraph 5 is where you can ask the court to order the injunction, which is in effect for not more than 10 years. If the court finds that a substantial risk of the respondent may commit first or second degree intentional homicide or first, second, or third degree sexual assault against the petition. This turns on the facts of your situation. If you believe that the respondent is going to try to kill or sexually assault, you could click on this. But this is only for homicide or sexual assault. This is not somebody calling you too often. This is a very serious request. So if you ask that, you need to have facts to back up your request to the court. Paragraph 6. If the court grants the injunction, the petitioner requests the court, A, not order the respondent to surrender his or her firearms, or B, order the respondent to surrender and not possess a firearm while the injunction is in effect because the petitioner believes that the respondent may use a firearm to cause physical harm to another or endanger public safety. If you know this person has guns and they're kind of crazy and violent, you can always ask the court to tell the respondent to surrender their arms. If they're not a gun person, if they don't have guns, then you would just stick with option A. Paragraph 7. This is where you would ask the court to direct the local sheriff to accompany you and assist in placing you in physical possession of your residence if requested. So let's say you lived with someone and the two of you had just a terrible fight that got physical, but it's your name on the lease and they won't leave the apartment. This is where you ask the court to help you get a sheriff or a sheriff's deputy to come with you and get your place of living back. It's always better to have a sheriff or a sheriff's deputy with you when this is going on. Don't do it on your own if you're asking for a protective order. So now you've asked the court for everything you believe you need to be safe, or at least as much as the court can offer you. The next really important step in filling out the petition is understanding how to properly serve the petition. It can't be effective if the respondent can claim they had no idea that it was there. So this is where service comes in, and this is also about every person's right to due process of law. Before the injunction hearing, it is the petitioner's responsibility to contact the sheriff's office or other process server. So you could hire a private process server, but the sheriff's office will usually do it for you. And let's face it, it's a lot more effective to have a sheriff's deputy show up in their uniform to serve these papers. To verify that the documents were served, and proof of service is filed with the clerk of circuit court. So the clerk of circuit court is the individual in your county that you file the petition who makes sure everything is filed and gets where it needs to go. And usually the sheriff's office or a private process server, when they serve papers on someone, they'll fill out an affidavit of service, and that will be filed with that proof of service will be filed with the clerk of court. The court will not handle service for you. It is your responsibility. And then they have some options here. If available in your county, another way to verify if the documents were served is to register with BPO, Vine Protective Order, and they offer you a link. But typically you would call the sheriff's office and ask if it was served, and they would tell you yes or no and provide you with proof of service. or if you hire a private process server, they will contact you as soon as they've served, and they will provide you with proof of service. Sometimes the process server and the sheriff's office will file with the clerk of circuit court, but that is something you would have to check with them about. Sometimes a respondent or defendant will either intentionally evade service or cannot be found. They're either hiding out from the process server or the sheriff's deputy, or they just don't have a home right now and they're maybe couch surfing and they're not working, so they can't be served at work. If you just cannot accomplish service through regular means, you can serve using something called service by publication. And you have to make sure that you use the proper form, which is Form 505, and it can be found in the same area that Form 405 was found. And what you do is you file with the court an affidavit stating that service by the sheriff or your private process server was unsuccessful because the respondent was either avoiding service by concealment or otherwise. You just can't get them served. You'll get an affidavit from the sheriff or your private process server saying that they could not complete service. So then you have to send the petition for TRO, notice of the hearing, to the respondent through mail or fax, and you need to provide proof of transmission. For example, a certified mail receipt or an affidavit of mailing or faxing. If you can't mail or send a fax because you don't have a post office address or a fax number, then you just have to tell the court that. And you have to be able to prove it. The clerk of circuit court will forward the TRO to the sheriff, and the sheriff will assist the petitioner in serving it. And if the sheriff wants a service fee under Wisconsin Statute 814-70 sub 1, you have to pay the fee directly to the sheriff. They'll tell you if you have to pay a service fee before they do anything. If the court checks box number 3 under the court order section of the Temporary Restraining Order and Notice of Hearing, which is Form 406, you don't have to pay a service fee. But I think a little more explanation on publication. You have to make sure that the court knows you just can't serve the person personally. Publication is an ad in the newspaper. That's how you serve by publication. And you would have to just take out an ad and let them know that a petition for a restraining order has been filed against them, and here's the hearing date. And the newspaper will run it and then provide you with what is known as an affidavit of publication. And you would attach that to your court documents to let the court know that you did everything in your power to make sure that the respondent was served. So at the bottom of the page, we have 2 blocks here. The left block is distribution. So who gets a copy of this petition when it's filed? The court, you keep a copy. A person who filed on your behalf gets a copy. The respondent gets a copy. The police get a copy. And then if there's somebody else who needs to get a copy, there's a place for you to enter that there. Over to the right, you have your signature block. Here's your affirmation. I declare under the penalty of false swearing that the information I have provided is true and accurate. Everything you include in this petition has got to be 100% true to the best of your knowledge. Stick with the facts. Only say what you know. Don't use any creative license. It's probably the best. Just stick to the very basic facts. And if you don't know something for sure, you can state it as an opinion. You can say it's my opinion that XYZ might be staying at location T. But don't say anything is a fact unless you know it's a fact for sure. Next, either you or the person who filled the form out for you will sign, printed or typed name, and date. So I talked a lot about doing attachments to this form. It's really important to just not try to modify the form. It says this at the bottom of every page. This form shall not be modified. It may be supplemented with additional material. Sometimes if you're handy with Adobe, somebody might just try to go in and, in the interest of keeping everything looking the same, might add additional lines to the form. Don't do that. Don't modify the form. Just do attachments and keep them organized in the way we discussed earlier in this video. So that is how you file or fill out a basic petition for a temporary restraining order, otherwise known as Wisconsin Civil Court Form 405. Thank you for watching. To learn more about restraining orders in Wisconsin, you can visit our page that's linked below.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.